I'll just start by saying that it's tremendous to be speaking at a conference where I'm referred to as Dave and Dave is referred to as David. What, of course, is a matter of renown is Rob's deep, uniquely rich and far-reaching influence on the intellectual and public life of this country. What is perhaps less well known is Rob's equally profound and inspiring influence on the personal lives of many, some of whom are in this room. I am one of those immensely fortunate people who have experienced this personally. Rob is my beloved uncle, a close friend and confidant. He has also had a formative effect on how I come at the world. In reflecting on this, I have been drawn back to my childhood recollections of Rob's central involvement in the resettlement of Indo-Chinese refugees and how he would sometimes engage in conversation with waiters in Chinese restaurants about how they were faring in Australia, and then explain to me why they'd escaped from harm in their homeland and come here. When I speak of coming at the world, about a way of coming at the world, what I'm speaking about is about thinking freely, thinking independently, thinking freshly, thinking hard, in fact, thinking very hard, and most of all, putting those ideas out into the public arena without fear or favour, and with a singular focus, offering ideas which give shape to where we've come from, to where we are now, to where we're headed, and to where we should head. Not as polemic to promote some tribal cause, but fundamentally for the public good. I'm reminded here of the late and truly great intellectual Tony Judt, a favourite thinker that Rob and I share, who advocated so passionately that ideas matter and that in this age we're in serious danger of losing a sense of their power and importance, and who implored us to, what he called, think socially, to make human rather than financial gain the aim of social policy as part of an overriding collective responsibility and duty of us all to one another. Rob is a beacon bright on this front. Now, it's true, as the introduction disclosed, that I work as a lawyer and director with refugees, but today I'm not going to talk about refugee law, or not primarily. I want to address a bigger overarching question, which is ultimately about the kind of society that we want to live in and to defend, and it's about one of the golden threads of the fair, the just and the good society, our commitment to the rule of law. And it's about the related question, which I'll call the ethics of protection, about why the law and morality matter, about what's at stake. On this point, let me start with a story. In August 2011, as I was cooking for the family on an early Saturday evening at my home in inner city Melbourne, I received a call for help. It was a distress call relayed through a young Canberra-based legal aid duty lawyer who told me that he'd just received a call out of the blue from a group of men incarcerated on Christmas Island wanting advice. These men, some of them from Afghanistan, feared being expelled to Malaysia. The matter was urgent, but precisely how urgent was unclear. Now, later that evening, I spoke by phone with some of the Afghan men seeking help. They were petrified. They explained through the aid of interpreters that they'd recently arrived in Australia seeking protection from persecution in their homeland, only to then be told by Australian officials that they would not be allowed to seek protection as refugees in Australia and instead were to be expelled to Malaysia. They told me they feared suffering more brutality in Malaysia and then deportation from Malaysia to life-threatening harm in their homelands. There was an extra complex twist. One of the men I spoke to, Mr. Shah, who became the lead plaintiff in the High Court case, sounded even more distressed about the plight of the unaccompanied children and families, that is, mothers and their children, who were incarcerated separately and out of reach on Christmas Island. They too wanted legal help, and he pleaded with me, "Can you please help them, Mr. David? Please do what you can. They need help like us." And my efforts that evening to speak with the unaccompanied children and the mothers failed. Immigration Department officials refused access despite my repeated requests for that access. I was told that they, that is the department and the private detention centre operators, were on alert. Alert for what, I asked? Well, if someone says something like lawyer, I was told. 6 of the unaccompanied children were only able to join the High Court action because the next morning, on Sunday morning, Mr Shah was able to recall their names from the boat journey and agree to act as their litigation guardian, while officials at the very same time from the department of their primary legal guardian, the Immigration Minister, were blocking access. All of this was happening on Australian soil. So that Saturday evening and the following Sunday morning, a legal team was assembled comprising some of the finest in their field in Australia, all acting pro bono. And with 24 hours, at 6 p.m. on Sunday evening, we were before the High Court of Australia in Melbourne, seeking an urgent injunction to stop the government from expelling our clients to Malaysia. And it's here that we learnt precisely how urgent the matter was, that 16 of the men were to be put on a plane at 11:30 a.m. the next morning, Monday morning. Now, the court granted an interim injunction that evening, effectively preventing the planned expulsions on Monday morning. And on Monday afternoon, the following day, that injunction was extended pending the outcome of the full determination of the matter before the full bench of the High Court. But that's how close these people came to losing their rights. And when you think about what's at stake, no less than life or liberty, no less than protection from brutal abuse, it reminds us, I think, of just how precarious access to lawyers and the law can be in this country. Now, about 3 weeks later, the High Court emphatically ruled by a majority of 6-1 that the government's proposed expulsion of these people to Malaysia was unlawful and prohibited. And I found myself with other members of the legal team crowded around a telephone in barristers' chambers in Melbourne telling 6 unaccompanied children and 36 men incarcerated thousands of kilometres away that they'd won their case. Now, for these very vulnerable people who are unlikely to have ever had anyone independent, let alone the law, spring to their defence through the trauma of their pasts, the sense of relief was deep and it was overwhelming. So was their sense of empowerment. Late last year, I had lunch near my office in Brunswick Street, Fitzroy, with Mr Shah to celebrate the grant of his permanent residence as a refugee. And this time we talked not of his fears of further peril, but of his future plans and dreams in his new homeland. To understand the context of the High Court challenge, we need to rewind a decade to the time of the Tampa. As we all know, 433 asylum seekers en route to Australia were refused entry and excluded from applying for protection under Australian law and were instead expelled to Nauru and Papua New Guinea for processing of claims and for warehousing, for human warehousing. This was done under laws enacted by the Parliament during the Tampa crisis in 2001, and it's the same laws, those laws, which were the subject of the Malaysia case in 2011. The policy was driven by a determination to deter people coming by boat who were seen as having arrived by way of secondary movement, a term otherwise less fortunately referred to by some as queue jumping. The idea was that having jumped a queue, taken an unfair advantage, if you like, and having managed to get here, these people could be punished. The fact that there were and are no real queues and no real protections accessible in the region en route to Australia didn't get in the way of prosecuting this policy. Nor do these facts seem to have stopped the recently appointed expert panel on asylum seekers recommending a so-called no advantage principle for asylum seekers who come here by boat. A recommendation now adopted, of course, by the government as policy, fully adopted. A policy which imagines an average waiting time for refugee resettlement in our region as the basis for determining how long someone is left languishing on Nauru when the UN Refugee Agency, the experts in this area, say the very assumption is wrong and that no such average exists. A policy still in search of a benchmark. A policy which has done nothing to discourage the perpetuation of perhaps the most toxic myth in the refugee area, queues and queue jumping. A policy which bears no resemblance at all to fundamental and long-established international principles and practice in the refugee arena. A policy, in fact, which should not be called a principle. A policy which, in effect, proposes to punish the very people we are meant to be protecting under our international treaty commitments. Now, as many of you in this room will be painfully aware, having read detailed accounts by Rob and others, history has shown that the practice of Pacific expulsion imposed severe and enduring harm on a mass scale to many innocent people. And yet, amidst the recent bout of political jousting over refugees, we've witnessed what I think is almost a strange revisionism, which somehow recast the Nauru option as humane, or at least inexorably and empirically proven as necessary to revive. In my judgment, this displays a disturbing disregard for the overwhelming evidence of the deep inhumanity and damage wrought by the experiment, which is happening again. Damage determined by the policy driving it, by its policy driving it all. Deterrence. Stopping the boats and consciously punishing those people who do manage to get here. It recalls the words of the late great historian Eric Hobsbawm, another shared favourite of Rob and I, when he wrote, "The destruction of the past is one of the most characteristic and eerie phenomena of the late 20th century. We live now in a sort of permanent present, lacking any organic relation to the public past of the times we live in. The past still speaks to the present for me, and I can assure you that during my work in Nauru, in the dying years of the Pacific Solution Mark I in 2006 and 2007, representing refugees, I saw firsthand unaccompanied children and grown men alike disintegrating, being crushed. Hauntingly, the same thing is happening again now. Back to the High Court case for a moment, and in essence, what the court found was that the expulsion of asylum seekers to Malaysia for processing would be unlawful because Malaysia was not bound by international or domestic law to process or to protect refugees. That was the essence of the finding. Despite the serious mischaracterisation of the case in the political and public discourse, as lawyers and the court somehow engaging in a determination of public policy, which involved activism and in fact even radical activism, the challenge was at a very fundamental level, just an ordinary, if not, I would say, conventional exercise of the role of lawyers, the courts and the law. The case involved a number of individuals wanting to question whether what the government proposed to do to them was unlawful. Nothing radical, nothing revolutionary. What was radical was the political response. It is a response which forms part of a pattern, in my view, in which an overarching characteristic of immigration law, refugee law and policy in the last decade and a half has been a radical deviation from ordinary legal principles, that is, the golden legal threads of the Australian legal system, such as access to the law, access to lawyers, to the courts, to habeas corpus, anti-discrimination principles, and the rule of law itself. With the revival of offshore processing in Australia in August last year, the protections introduced by Parliament in 2001 have been abandoned by this Parliament. New laws based on past bills were urgently passed in a mood which I feel sort of evoked the frenzied temper of the Tampa period. These laws have effectively stripped bare the statute of the fundamental protections which had been interpreted by the High Court to prevent expulsion of asylum seekers to places without proper protections backed by law. Now, when deciding to expel asylum seekers abroad, the Minister of the day does not have to consider the availability of international human rights or domestic law protections in another country because they are now not relevant. How do we know? Because the statute overtly says so. They're not relevant. The rules of natural justice are expressly ousted. The only condition imposed upon the exercise of the power, the only limit, is whether the minister considers the transfer to be in the, quote, national interest, unquote, whatever that may mean, whenever. It hands to the minister of the day an almost unlimited power to expel an asylum seeker anywhere at any time without having to consider what would happen to them. As if the Refugees Convention comes with an on-off or a pause button, and Parliament can just press pause. The concern here is not with the engagement by the Executive in Parliament in one of its clearly legitimate and necessary functions, that of lawmaking. The concern here is the nature of the laws which have been made. That is, that to circumvent the court's ruling, it's been considered necessary to all but remove the role of the courts and thus the ordinary operation of the rule of law, to take the law out of the law. Now we have laws where the executive decides for itself whether it's applying the responsibilities to refugees which it accepts it has. Just trust us, it says. Now, what does all this amount to? And it's here that I want to bring us back briefly to the big overarching theme, I think the common thread in our recent High Court cases, the 2010 case of M61 on offshore processing, the 2011 case M70, the Malaysia case that is, and the most recent case last year, M47, the indefinite detention of a refugee on security grounds, and in the legal landscape more generally. It's about a deep and ever-deepening tension that's emerged between the executive and the judiciary about who makes decisions and how those decisions are made, about the power of the executive and the constraints on this power on two core issues. One, individual liberty, and two, decision-making powers. There has been a persistent pattern of governments fiercely resisting scrutiny by the judiciary and seeking to impose policy-based decision-making schemes which operate on executive fiat outside the rule of law. A stark example of this pattern at present is the government's preliminary response to the security case that I just mentioned, the indefinite detention of a refugee on security grounds. The government has conceded the need for an open and accountable process for review of ASIO's security assessments for refugees, but has announced a new review system which is anything but that. The inherent weakness of the process is that it's not set in law and ASIO is not bound to follow an independent reviewer's recommendations. The lack of external scrutiny with the force of law on matters which so gravely affect a person's liberty is, in my view, extraordinary and disturbing. It means that even if the reviewer says ASIO got it wrong and the person's not in fact a security risk, ASIO can ignore it and a person could be left locked up indefinitely without having been charged, tried or convicted and without legal redress, stuck possibly forever in a cruel and inhuman Kafkaesque twilight world. So in light of this current executive trend to oust independent scrutiny and the rule of law on questions as grave as freedom from unlimited incarceration, and in the absence of a federal human rights charter or a constitution with more than a mere smattering of enforceable human rights, what can be done? Is there anything left in the law to protect an individual's liberty? The principle of legality is, in my view, one such source of protection, and a potentially potent one at that. It is said to be a unifying concept encompassing centuries of common law jurisprudence, and at its heart lies the idea, in the words of Chief Justice French, that, and I quote, "The rule of law posits legality as an essential presupposition for political liberty, and the presumption that Parliament does not intend to invade fundamental rights, freedoms and immunities, or to interfere with rights such as access to the courts, procedural fairness, or equality of religion or of liberty." Courts interpret statutes on the assumption that they were not intended to trample fundamental rights or freedoms. And in the absence of a Bill of Rights, we have recently witnessed the development of fundamental rights through this principle. As it develops, the protective scope of the principle is unclear, but it may hold the key, may hold at least a key, to the protection of the rights and freedoms of even the most apparently unpopular individuals or causes. And coming back to M47, the security case in the High Court for a moment, we may have seen the potential for further development of the principle of legality, which has largely escaped attention. By reference to the principle of legality, Justices Gummow and Bell held that indefinite detention was not permitted in the absence of clear authorisation by Parliament. And to give a brief example, in Justice Gummow's view, Parliament had not squarely confronted the indefinite detention because Parliament had not squarely confronted the indefinite detention of non-citizens, it would not be right to construe the Act as if Parliament had authorised it. It would be an error to do so. Justice Bell affirmed that she affirmed the fundamental nature of the right to personal liberty was not confined to Australian citizens, and that the 2004 High Court judgment of Al-Khatib, which found notoriously that it was lawful to lock up an asylum seeker indefinitely, was weakened by its failure to refer to the principle of legality and the presumption of liberty it bestows. Therefore, the principle of legality was again affirmed as part of the constitutional relationship between the courts and Parliament and as an aspect of the rule of law. And the principle formed the bedrock of a growing body of legal reasoning that says this at its heart: indefinite incarceration of an individual, of an innocent individual, an asylum seeker or refugee, is unlawful in this land. Ultimately, the majority of the court decided it was not necessary to determine whether it was lawful to detain a refugee indefinitely because of their invalidation of a regulation which in effect gave ASIO a self-executing power to deny a person the grant of a visa and their freedom. As it now stands, 56 refugees remain indefinitely incarcerated. The question of the legality of the detention of many of them remains tantalisingly open. Why does this matter? Not only because we've agreed with the international community to comply, why does the law matter? Not only because we've agreed with the international community to comply, and as a wealthy nation are well placed to do so, but because these laws and principles and the principles underpinning them have been painstakingly designed to provide real protection to people in their daily lives. It's not about legal niceties, which can be dismissed as inconvenient or outdated in more trying times. As soon as we press the pause button on our legal obligations, we jeopardise the safety of the very people that these laws have been designed to protect. The law, human rights law, is of course also deeply rooted in ethics, and we must confront the ethical dimension. The current policy of Pacific Solution Mark II is consciously harming people fleeing from harm, purportedly in the name of stopping the boats, protecting our borders, breaking the business models of people smugglers, and/or saving lives at sea. This squarely raises the key ethical question whether we may do something awful to achieve a good outcome, or does the end justify the means? In my judgment, to condemn people to unnecessary and inevitable abuse is completely unjustifiable. Asylum seekers, refugees will endure the agony of uncertainty as they are now without the prospect of timely due process or resettlement, and they'll be stripped of their liberty and be kept separated from their family and from a future. It is not, as has been asserted by some, a necessity to do this. It is a conscious choice. And the logic underpinning this choice of deterrence policy is brutal. The more painful the penalty, the more effective the outcome. Under this logic, it is suddenly acceptable, if not necessary, to expel a child to a country like Malaysia or Nauru, where there are no guarantees to guard against further harm or abuse, all in order to deter others from coming here. So what should guide our refugee policy? Well, in his 2003 quarterly essay, Sending Them Home, his and Dave's, Rob offered reasons for why we should take in and help those people arriving on our shores rather than expelling them, as the ethics of proximity, the essence of which is the moral imperative created by the presence of the person on our doorstep, and akin, if you like, to the Good Samaritan parable. Drawing upon this idea, I'd like to propose another expanded idea with some similar strands about what should guide our approach to refugee policy, what I'd like to call the ethics of protection. Now, the ethics of protection recognises the necessary and close interrelationship between the core legal, moral and practical dimensions of protection and the need to draw them all together, to fuse them. It requires that policies be based on protecting, not punishing people, promoting human dignity, not abusing it, and that in action we must protect those on our doorstep, not shut the door in their face, that we must take steps to minimise harm, not steps which compound it. The ethics of protection also recognises the special importance of the context here, that we are responding to the needs of vulnerable people fleeing from harm and must ensure that what we do contributes to restoration of the rebuilding of people's lives, not exacerbation of harm or destruction of lives. Why? Because it is what we've committed to do by law, laws and commitments which directly reflect what is morally acceptable treatment and which are carefully constructed to protect rather than further punish people in practice. So in closing, I want to bring us back to our recent past. And it seems that there are at least two 20th anniversaries of profound significance in the nation's history which have just passed. One, a beacon bright, where the law found a fair go for Indigenous people, Mabo, and the other, the introduction of mandatory indefinite detention for asylum seekers who arrive here informally, surely one of the darker anniversaries this country has had to mark. After 20 years of systematically incarcerating large numbers of women, children and grown men alike, people who have committed no crime and who in fact have fled from terrible crimes against their human rights, I think we're in serious danger of accepting and institutionalising a practice which betrays what for centuries has been a fundamental tenet of life under the rule of law, habeas corpus and individual liberty. Why is it that we have become inured to this, so that we have come to accept, it seems, without the nation flinching, a situation where it is the norm to lock up innocent people and often destroy them in pursuit of policy or political imperatives of the day? As shocking as this may seem, there has been no serious revolt in the body politic or in the public. When almost a decade ago, Rob wrote a heart-wrenching op-ed piece in the Age newspaper about the destruction of a 6-year-old Iranian refugee boy, Shaim Badrai, held in long-term detention, who had become so traumatised by his experiences that he no longer talked, ate or drank, and Four Corners depicted the horror of it firsthand, there was no significant public outcry. Nor has there been in the countless other cases of children who have since suffered severe abuse due to prolonged detention. Why does this matter? What's at stake? Well, here we are not talking about highfalutin legal principles. We're talking about the predicament of people, the dignity of fellow human beings, and we must never forget the real cost of this, the real face of it. The man who brought the recent High Court security case is known by an initial and by a number, M47. But he is also a man with a heartbeat, and he's a man who is suffering. And this is what he wrote to me recently from the detention centre in which he has been held for over 3 years. My feelings are dead. I have my body and my soul only. All of the parts of my body are now stopped working properly. Hearing, looking, tasting, and all feelings are gone, and I am living without anything. Thank you.